13248 FH, People versus James Cornelius Stewart. And Mr. Stewart, we arranged on this probation violation warrant, and the court received an amended warrant adding 2 additional alleged violations. Did you get that paperwork?
Yes, Your Honor, yes.
Okay, so what they're alleging is that you violated condition number 1, that you not violate any criminal law of unit of government, and the allegation is that on or about December 11th of this year, that you drove a motor vehicle without a valid license, and you got charged in Wyoming for driving license suspended. Do you understand the allegation contained in count 3?
Yes.
All right, count 4 is that you were in possession of drug paraphernalia, and you pled guilty to possession of drug paraphernalia in the 68 District Court in Wyoming. Do you understand the allegations contained in count 4?
Yes.
All right. And Mr. Prysock, well, let me do it this way. There's been a recommendation made in this case that his probation be terminated unsuccessful, that he be ordered to serve up to 12 months in the New York County Jail with credit for 119. And Mr. Walburn, do you adopt that recommendation as an offer in this case?
I do, Your Honor.
And Mr. Prysock, is that your understanding of the offer in this case?
Yes, Judge.
All right. And have you had a chance to discuss these 2 new added allegations with Mr. Stewart and this offer?
Yes, Judge.
Okay. And what does Mr. Stewart want to do today?
Well, Judge, there's an added bit of information for the court. James was also charged with possession of methamphetamine and possession of cocaine. And the case dates back to June of 2023 and scheduled for a PCC on December 26th. However,
What county is that?
our county, it's here in New England.
Okay.
However, when I look at his original police report and his PSI from back when he was originally sentenced in this case, it seems that the new charges were dealt with at that time. It's kind of like they came up again. And so Mr. Walburn and I are looking into that situation, because I think his original sentence, the court had given him credit for time served of 113 days and released him from jail when we were here and put him on probation. So it's kind of I don't know where that other case is going to go, Judge. And I don't know whether how it affects our situation here today. I mean, Mr. Stewart is prepared to enter a plea to those 2 new allegations because he's already pled to those charges in Wyoming and he's been sentenced. So there's no harm for him to enter a plea to those charges with any outstanding cases. And these new cases are not a basis of the violation. So I don't know how the court wants to proceed with something like this. Once we get to the PCC, these new cases may be dismissed because I think they were already dealt with back in 2023 when he was in front of the court. The court sentenced him on charge. I mean, everything reads pretty much similar to what it was back in 2023. So I don't know how the court wants to proceed given that information.
Well, I would just take the probation allegations that are pled so far and deal with those. And then whatever happens on the new stuff, we'll deal with that when it comes.
Yeah, that sounds good, Judge. And that's something that James and I discussed as to how we may proceed. So I think he'll enter a plea to those 2 allegations that he drove without a license and that he was in possession of drug paraphernalia. The other charges may be in dispute, but I think those 2 would satisfy probation violation.
Okay, is that what you want to do, Mr. Stewart?
Yes, Your Honor.
All right, would you raise your right hand, please? You solemnly swear oath or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, so the allegations here are that you were placed on probation to this court for possession of a controlled substance, narcotic, less than 25 grams, and that was on or about October 2nd, 2023. You understand that?
Yes, sir.
All right. And the allegations here are that you violated condition number 1 of your probation, that you not violate any criminal law of any unit of government, and that on or about December 11th, 2025, that you violated the state law by number 1, driving without a valid license, and number 2, having a drug paraphernalia. Do you understand the allegations again that are raised in counts 3 and counts 4?
Yes.
Understand that if the court accepts your guilty plea to those, your probation would be terminated on this case.
Yes.
And that you'd be looking at jail time up to 1 year in the county jail. You understand that?
Yes.
Is that your complete understanding of the plea agreement in this case?
Yes.
Have you had sufficient time to consult with Mr. Prysock about these allegations, the right to contest them at a hearing, and this plea agreement?
Yes, I have.
All right, and then subject to the plea agreement, how do you wish to plead?
Yes.
Do you understand that if I accept your guilty plea, you're giving up the right to contest these allegations at a hearing?
Yes.
You also understand that you're giving up the rights that you would have at that hearing?
Yes.
We've listed those rights for you on a written advice of rights sheet that you signed on December 12th. Did you read that document?
Yes, Your Honor.
Did you understand those rights?
Yes, sir.
Do you also understand that you might be giving up the right to appeal any appealable issues you may have if you had a contested hearing and I found you guilty?
Yes.
Do you understand that you are giving up the right to appeal this conviction and sentence? And if you wish to file an appeal, it would be by application for leave to appeal in the Court of Appeals, and it's not an appeal by right.
Yes.
Has anyone threatened you to get you to make this plea?
No.
Has anyone promised you an outcome different than what we put on the record?
No.
Are you entering this plea of your own free will?
Yes.
Is it true that you were placed on probation to this court October 2nd, 2023 for possession of a narcotic less than 25 grams?
Yes.
Is it also true that a condition of your probation was that you not violate any criminal law of any unit of government? Did you violate that condition on or about December 11th, 2025?
What?
Did you violate that condition December 11th, 2025? Were you driving a motor vehicle?
Yes.
Did you have a valid license?
No.
Do you know why you don't have a license?
I've been trying. And I can't seem to get nowhere with it.
Okay, but did you lose it for drinking and driving or for drugs or
No,
child support or?
Driving off of suspension.
Okay, all right. And as a result of that traffic stop, did they find some drug paraphernalia?
Yes.
What did you have?
It was in a coat that I had picked up.
Okay, but what was it?
Pipe.
All right, that was your pipe?
No.
Did
It
you know it was
was
in
my
your
coat.
pocket? Did you know it was in your pocket?
No, if I did, I'd have threw it away.
Okay, so you didn't knowingly or intentionally possess that item of paraphernalia?
No.
Did you plead guilty?
Yes, they did get it over with. People going through a whole bunch of stuff.
Okay, I can't take your plea to that.
Cause I was in a coat.
But the court could accept this plea to the
Right.
DWLS.
Mr. Stewart, I don't believe you. I mean, if you knew how many times people said, that wasn't my drugs, it wasn't my coat, it wasn't my pants, I don't know how that got in my bra. I mean, I've heard it all. You do have a history of drug use. It wouldn't be surprising to me that if you had some sort of paraphernalia on you. And you knew it?
Well, if I knew it, I wouldn't have had it.
Okay, all right. So, all right, the court cannot accept your plea on that count. Mr. Walver, do you want to continue with just the drive without a valid license?
Yes, Your Honor, it's not going to change anything. It's non-technical recommendation. It's going to be the same.
All right. All right. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
There are none, Judge.
Is he competent to enter this plea?
It is, Your Honor.
He is.
Does the court comply with the court for taking a plea in a probation violation case?
I have, Your Honor.
Court has.
Court does find the plea to be knowing, understanding, voluntary, and accurate. There's been an updated report. Was it timely made available to you?
Was, Your Honor.
Yes, Judge, it was.
Do the parties want to proceed to sentencing today?
Yes, Your Honor.
We do.
And Mr. Price, I give you the opportunity to read the report and discuss it with Mr. Stewart.
I have.
Do you have any additions, corrections, or challenges?
I do not.
Anything that you want to say on his behalf?
Would ask the court to consider giving him credit for time served on this case. We'll deal with the other case when it comes up in district court next week. But with this one, Judge, we're asking the court to give him credit for time. I think he served a few, how many days did he serve in Kent County? Can you remember?
I think it was two or three, but can't remember.
That's all, then you went in and did a clean, the judge released you.
Yes.
And put you on probation?
No.
Okay. Nothing else, Judge.
That's fine.
All right, and Mr. Stewart, did you have the opportunity to read the updated pre-sentence report?
Yes, I did.
Okay, and do you have any additions, corrections, or challenges? In other words, was the report accurate?
Yes.
Is there anything that you want to say on your own behalf?
No, not at this time.
Mr. Walburn, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Just ask you sentence in accordance with the plea deal.
All right. Now, the court recognizes that the advisory guidelines would suggest a sentence between 0 and 9 months. The court can exercise by discretion, sentence consistent with the advisory guidelines, consistent with the agreement in this case. It would be the sentence of the court that this defendant serve 210 days in the Nuevo County Jail. Give him credit for the 119 that he's already served. I'm going to discharge him unsuccessfully from probation. And Mr. Stewart, you still owe $477.60. You haven't paid a dime on this court in the last couple of years. You need to pay that within 90 days of your release from jail. You do have the right to make applications for you to appeal this conviction sentence. If you're not a court attorney, the court appointed attorney to represent you on the appeal. Request for lawyer must be filed with court within 42 days.
You got your own case to deal with. So you don't have other cases. Sit on that case anyway, so this case is I'll see you as soon as I get some information on that other case. All right. Yeah.
We have Attorney Mason and Defendant Zinni. Are they back there?
I have Mr. Zinni.
Okay. I don't know where his lawyer is. Why don't we hang on, Deputy Herman's, I don't know where his attorney is at this point. I saw him earlier, but let's skip him and we'll come back to him when his attorney. Okay, court.
Now, Judge, I never received a notice of appearance or anything on the case. So I went to see Mr. Zinni yesterday, and I guess he does have. I never received anything from another attorney.
But yeah, we just got it submitted to us this morning. Substitution of attorneys, it's dated October 15th, but we just got it dropped off today.
Well, that's when we were told about it.
Yeah.
And it's, well, okay, send us the stuff, and we never got anything. So, all right, so he does have somebody else. Perfect.
Yeah. All right, let's deal with sentencing on Jacob Cooper. This is case number 2513652 FH, People versus Jacob Leroy Cooper. Mr. Cooper is here for sentencing. Prosecution and defense was the pre-sentence investigation report timely made available to you?
Yes, Your Honor.
Well, Judge,
And Mr. Prysock, have you had the opportunity to read the report and discuss it with your client?
I have, Judge.
Do you have any additions, corrections, or challenges?
No, Your Honor, I do not.
Anything that you'd like to say on his behalf?
Well, Judge, he's unable to pay that lump sum payment, take advantage of the 11-month delayed sentence. He advises me that he is able to pay $500 this month. Okay, and you're gonna pay that every month?
Hang on, one at a time.
All right, so he's gonna pay $500 this month, and he intends to pay $500 every month thereafter. I think that's what the original order was, $553. So that's where we are with it today, Judge. He was unable to come up with a lump sum payment.
Okay. All right. And Mr. Cooper, have you had the opportunity to read the report and discuss it with Mr. Prysock?
I have.
Do you have any additions, corrections, or challenges?
No.
Anything that you want to say on your own behalf?
I have $300 I'm gonna put on a card today to pay my child. And then I'll have 200 in a couple weeks. 553 every month after.
The PSI says that you're not working. Do you have a job now?
I'm working on the side right now, working on cars. And I'm making pretty good doing it. It's through a buddy of mine. He pays me cash.
So your buddy has a business and he pays you in cash. Why doesn't he pay you on a paycheck?
This is the way we got it right this second. I just started. So if I work out, he's gonna switch me over. Then it'll be checked.
Report says that you basically $24,500. That tells me you haven't paid for a really long time.
My child support was up to 1,000. So I couldn't afford it. Wasn't working at the time, and couldn't afford $1,000 a month. And I just got it lowered to 553.
When it was set at $1,000 a month, were you working then?
At first I was.
Okay.
And then I lost that job because I got really sick. Got diabetes too, pancreatitis, and then now I got some other problems. I'm trying to work past all that to keep going and make my things. I know I messed up.
All right. And Ms. Berta, any additions, corrections, or challenges?
No corrections to scoring, Your Honor. I would update the court as to the amount of the arrearage, which as of December 12 is $25,023.12. It is accruing at $528 a month. Defendant, since being released after just a couple days, has only paid $100 on July 29. There's been nothing since then. That's the only amount, but for a $2,500 bond that was applied earlier this year. Prior to that, it was April of 24 that he made any payments. So, Your Honor, given the sizable arrearages in this matter, we would ask the court to place him on a 3-year term of probation. Further, Your Honor, we would ask that he be ordered to pay his child support and arrearages as a term of probation. I did not see it in the recommended order, Your Honor, and I would ask the court to add that as an additional paragraph.
All right. How much time, jail time, if any, do you think is appropriate for Mr. Cooper?
Given his few efforts to find any employment or make any payments, his guideline range is 5 to 23 months. I believe 5 months would be appropriate.
All right, thank you, ma'am. Mr. Cooper, have you had various show causes through the front of the court for failing to pay child support?
Yes.
Have you done jail time for that before?
I was picked up and had to pay to get out. It was pay or stay. That's what I paid got 2,500 over the
That's the only time that you've done jail time for that?
He has one today, Judge, at 10 o'clock
I got
with friend of the court. Forgot to mention that to you. He has a hearing scheduled as soon as we finish here.
I believe that would be the 8th show cause, Your Honor.
The show cause, isn't it?
No, I'm saying I believe that would be number 8
Yeah,
in terms of how many
Yeah.
show causes.
Yeah, I understand that certainly there should have been a bunch of show cause. I just wonder if he's ever been in jail for it.
Tell from my report, Your Honor.
Okay, all right. But the court recognizes that the advisory guidelines for each one of these 3 offenses would suggest a sentence between 5 and 23 months. Now, the court's going to exercise my discretion and do a downward departure in this case. Certainly, the court understands the statutory scheme where failing to pay your child support is a criminal offense, and it should be. It also can be punished by contempt of court, through a different system. I haven't really been able to figure out over time how some cases get charged criminally through the Attorney General's office and some don't. So and it's not always the amount of the arrearages. It's not always the amount of payments. I don't know. I guess maybe it's the squeaky wheel gets the grease. But I'm taking the approach that if this were just proceeded through a contempt of court situation, that given 8 prior show causes, that if I was sitting on that case, I'd probably give you 90 days in jail. So that's what the court's going to do. It'll be 90 days in jail, credit for 3 days. There's a $68 state cost assessment for each of these 3 accounts. There's $130 crime victims' rights fund fee. The court is going to make it a condition of your probation that you pay the current amount of support as ordered and the amount and an amount towards arrearages as set by the family division of the 27th Circuit Court. There is going to be a $30 per month probation oversight fee for regular probation, $60 a month for electronic monitoring or tether. The areas that would be addressed on probation are those appearing as highly probable under the core compass needs scale. And probation will be for 3 years. You do have the right to make application if leave to appeal your conviction sentence. If you cannot afford an attorney, the court appointed attorney represents you on the appeal. Request a lawyer must be filed in court within 42 days.
Yeah, cut it down to 90 days. But yeah, you gotta serve some jail. Those are 5 months to